Hi guys, welcome back to Shafi's Academy. My name is Anuja and I will be teaching the subject Jurisprudence, Interpretation and General Laws. A little bit about me. I completed my law degree from Christ University, Bangalore in the year 2018. I am also currently pursuing my company secretaryship, the executive level, and I will be writing my Module 2 exam this coming December 2020. Now, a little bit about the subject itself before we delve into the details of the subject. I would like to introduce you students about this very subject. Now, as you all know, it is the first paper in Module 1. And the purpose behind this subject, the introducing the subject for company secretaries is very simple. It is meant to introduce all you students to the concept of law, understanding that law, interpreting that law, and generally introducing you all to the various laws that exist in our country. Now, many of you all know that there are multiple laws that are applicable in all walks of life in our country, whether they are civil laws, whether they are criminal laws, corporate laws, foreign exchange laws, name it, and those laws are there. Now, as a company secretary, we are very much interested in those laws that affect the governance or affect the liabilities of a company, a partnership firm, or any such corporate entity. Now, in Module 1 itself, other than this subject, other than the subject of jurisprudence, interpretation, and general laws, which I will call JIGL in its short form, you have such other laws such as company law, tax laws, whether it is direct tax laws or whether it is indirect tax laws. The essence of it is still a law. And JIGL is meant to introduce you all to such laws, introduce them as well as teach you how to interpret them. That's what you mean by the word interpretation. So you see, when you take the bare legislation as it is drafted by the parliament, when you do a reading of it, you may notice that you do not understand certain words, or you may not understand the meaning of certain sentences, and just generally the very structuring of the entire law itself may seem very confusing. This subject is meant to clarify those doubts and, more importantly, help you all understand how to go about reading that law. Now, if you look at the word jurisprudence, jurisprudence literally means study of law. It will introduce you to the history of law and how law has evolved over a period of time. And more importantly, there is a lot of emphasis on the sources of Indian law. How has Indian law developed over time and how is it applicable to us today? So we will be touching upon topics of primary sources of Indian law and secondary sources of Indian law. And now moving on to the general laws part, it is believed that every person who studies about law must have a general understanding of some very basic laws, whether it is the Constitution of India or whether they're the core civil laws, the core criminal laws, and just generally such other laws which would be applicable to a corporate structure. Now, let's move on to the very structure of this entire subject. Module 1, paper 1 is divided into, is a 100-mark paper. It is entirely theoretical and you will not find any MCQ format in this paper. There are 17 chapters and each of these 17 chapters will introduce you to various areas or various areas which are applicable in a corporate scenario. And most of them do not always involve a corporate structure. Most even involve the rights of individuals. So coming to the subject itself, let's look at the first chapter. The first chapter is known as sources of law. Now, I would like to divide this chapter into two parts. The first part will touch upon topics such as the history of law, and we will study about various definitions given by different jurists over a period of time. Now, I wouldn't say that these are definitions given after independence or before independence. I am talking about these definitions given by thinkers worldwide through different periods of time. And this is meant to help us understand where law comes from, why we need this law. And the second part of this chapter goes on to explain what are the sources of Indian law. Now, since we are in India and it is mostly the Indian laws that will be applicable to us, it is very, very important to understand where laws in our country get its power from. And we will be studying about the primary sources of law as well as the secondary sources of law. Coming to the second chapter, we will be studying about the Constitution of India. Now, in this chapter, we will touch upon a wide variety of topics, whether it is from, we'll study about the preamble, about the fundamental rights, fundamental duties, the directive principles of state policies. We will study about the powers of the president and the governor. We will study about how power sharing is formulated the between the parliament, and more importantly, we'll study about how does parliament formulate these laws, how do they legislate these laws. So another thing that you need to know about the Constitution of India is that it is the most powerful law in this entire country. In fact, I would call it the law of the land. You see, every other law that you see around you, or any law which is applicable to you, has to get its power from the Constitution of India. And it is for this reason that the Constitution that you are studying about this particular chapter. Now, moving on, let's move on to the chapter number 5. Chapter number 5 is known as administrative laws. These administrative laws is, I would say, a continuation of constitutional law. Now, you see, unlike every other law that we will study about, administrative law does not come from any particular legislation. You can find administrative laws from multiple sources, the main source being the Constitution of India, other laws, judicial decisions or judicial judgments, etc., and such other orders, notifications, etc. So you see, administrative law governs that part of the Constitution which involves the administration or the executive leg of the Constitution. Moving on there coming back to chapter number 3 and 4. Chapter number 3 talks about interpretation of statutes. So you see, like I said earlier, when you open the bare legislation as it is drafted by the Parliament, like I said, it may be ambiguous. You may not understand certain terms. You may not understand the meaning of certain terms. And in fact, you would notice that the very language present in that particular law will be very different from the colloquial language as we speak in day-to-day terms. And it is for this reason that it is very, very important to understand certain principles, certain theorems which are applicable. And you have to apply these theorems and principles while interpreting these laws. Now, if I take a storybook in my hand and if I take the law in my hand, the difference between the two is that when you're reading the storybook, it is written in very simple terminology. It is written in such a way that you're meant to understand it. Now, while laws are also made in the exact same way, the purpose of laws is such that you are meant to understand it. There are certain laws known as the Income Tax Act, which may seem very, very confusing to the common man. And it is here that interpretation of statutes come into play. This interpretation of statutes introduces us to certain principles and certain aids of interpretation, which will help us understanding the reading of that bare law much, much better. Now, coming to the next chapter, that is the General Clauses Act. This was a legislation which was drafted during the colonial time. Like you can see, it is known as the General Clauses Act of the year 1897. The purpose of this entire law was to give definitions, all right? Even if you had to take something as simple as movable property. Now, you and I know that movable property means any property which can be moved from one place to another. Now, the purpose of this law is that they wanted to give certain definitions, a certain standard to certain meanings of certain words, so that it is applicable in a uniform manner to everybody. And you'll notice once we delve into this chapter, there will be multiple definitions given in this particular chapter. All right, moving on. Let's move on to chapter number 6, which is known as Law of Torts. Law of Torts I would say touches upon the civil laws. Till now, we spoke about the Constitution of India and generally about how to interpret laws in general, whether it's a constitution or any other laws. But now we're touching upon the civil laws, the basis of the civil laws, and that is known as law of torts. In this particular chapter, we will be introduced to the concept of a tort, what are the elements of a tort, and more importantly, they will give you certain definitions. No, I wouldn't say definitions. I would say certain examples so as to help the students better understand what amounts to a tort. Moving on, let's move on to chapter number 8, wherein it is known as the Civil Procedure Code of the year 1908. Now, the Civil Procedure Code, or in short form, the CPC, forms the very core, the very base of all civil laws. And this particular law is divided into two parts. The first part lays down all the civil rights and liabilities of parties involved, and the second part lays down the procedure as to go about. What is the procedure to be followed while applying these particular civil laws to persons. Now, this law of torts and the Civil Procedure Code is meant to guide students, or more importantly, to open up a world to help them understand what is the procedure or what is the format by which any litigant, when I say litigant, it is a person who is approaching the court. The Civil Procedure Code helps lay out the format as to how to approach these courts, what is the process to be followed, what documents should be filed, what is the time limits for certain things. All of that is laid down in the Civil Procedure Code. Moving on to chapter number 9 and 10. Now, 9 and 10 gives you an introduction to criminal laws. Okay, the first one, chapter number 9, talks about the Indian Penal Code of the year 1860. And in short form, I will call it as the IPC. Now, the IPC basically defines what are offenses, or more importantly, criminal offenses. And the purpose of understanding, of studying about the IPC is to understand what amounts to a criminal offense and whether companies, while doing any act, are actually committing a criminal offense. Okay, so you are introduced to topics such as criminal misappropriation of property, breach of trust, cheating, fraud, offenses relating to documents, and forgery, defamation, etc. Whereas the Criminal Procedure Code, that is chapter number 10, the Criminal Procedure Code of 1973, also the short form is CRPC. The CRPC lays down the procedure of it lays down the procedure as to how to approach a criminal court to go about claiming rights and liabilities in the case of a criminal offense. Now, while the Civil Procedure Code is the basis of the civil laws, it itself is divided into both its substantive law and its procedural law. Whereas for the criminal laws, the IPC consists solely of its substantive laws, whereas the Criminal Procedure Code consists solely of the procedural laws. Now, you may ask, what is the meaning of substantive law and procedural law? I can put it across to you in a very simple manner. Substantive law lays down the rights and liabilities of parties. Okay, I wouldn't say parties, I would say each and every person that this law is applicable to. Do I have the right to own property? Do I have the right to protect my property? Do I have the right to enter into a contract? Do I have the right, what will happen in case of breach of contract? Then in case an offense is committed against me, then what rights of mine have been violated? These are the things which amount to substantive law. That means it's either laying down the rights of parties involved, or it's laying down the liabilities of parties involved if they violate the rights of any other person. This is what substantive law is. Whereas procedural law is basically the procedure to go about while enforcing the substantive law. It is just as simple as that. Hence, Your IPC 1860 is largely a substantive law legislation, or I wouldn't call this a legislation, I would call it a code. Whereas the CRPC, or the Criminal Procedure Code of 1973, is the procedural aspect of the criminal laws. I hope you'll understand the difference between these civil laws and the criminal laws. Now, moving on, chapter number 11, you have the Indian Evidence Act of 1872. Now, one of the processes, or one of the main processes of approaching the court is that when you're alleging that another person has committed a crime, or has committed an offense, or has committed a tort, you have to provide evidence for the same. And it is this law that governs all the rules of evidence. That is, which evidence can be submitted, which evidence cannot be submitted, which evidence is proper evidence, which evidence is improper evidence, what amounts to uh, um, opinion of third persons, whether evidence should be submitted in oral form or whether evidence should be submitted in documentary form. These are the rules that we will be studying under Indian Evidence Act. Now, coming back to chapter number 7, if you'll notice, I missed out this chapter earlier because I wanted to approach this chapter after finishing the Indian Evidence Act. You'll notice that chapter number 7 is known as the Limitation Act of 1963. The reasoning behind this piece of legislation is very simple. It states that when the government or the state provides certain rights to people or provides certain remedies in case that right is violated, then the assumption is that the victim must approach the courts as soon as possible or whenever it is possible. Now, let's assume that a person owned property whereby it got trespassed upon. And a trespass is a right against which he can approach the court and get a remedy for. Now, this person, the owner of the property, approaches the court 10 years later. He approaches the court 10 years later, alleging that another person had trespassed into his property. Now, what the government believes, or what the law in general believes, is that if your rights have been violated, you must approach the court as soon as possible. You cannot sleep over your own rights. And as a result of which, they're stating that for so-and-so offenses, you have to approach this court within a certain limitation period. And then they state, with regards to immovable property, you can even approach the court after 30 years. But with regards to, say, contract, or with, say, regards to certain appeals, the time limit is much, much lesser, ranging from even 10 days to even 60 days. And if you do not approach the court within this particular period of time, then it is assumed that you have slept over your rights and you can no longer approach the court for any remedy. That is the purpose of the Limitation Act. And once we delve into this particular chapter, you will notice there is a huge table laying out different scenarios or different situations and the time period within which you must approach the court for the same. This is the gist of Limitation Act. Now, so far I have given you a summary of 11 chapters. Let's move on to the remaining chapters. Coming to chapter number 12. Chapter number 12 is titled Special Courts, Tribunals under Companies Act, and Other Legislations. Now, for those of you who have started studying about company law, or even have a general vague understanding of company law, and for those who don't know yet, all matters regarding Companies Act or all disputes regarding companies will be heard not by the civil courts, but rather it will be heard by an authority known as the National Company Law Tribunal. And this is a tribunal. Now, what is a tribunal and what is a court? A tribunal is very similar to a court, but the assumption is that the courts have a backlog of cases. They have multiple cases and they have multiple proceedings to hear every day. And it is believed that if the courts continue to listen to certain matters, justice will be delayed. So what the government and what the law itself has set up is something known as a tribunal, whereby these are court-like structures, whereby there will be a presiding judge or two presiding judges, whereby they will listen to all matters regarding the Companies Act. All right. Now, in this chapter, special courts, tribunals under Companies Act, and other legislations, we will study about all of these court structures which are not the civil courts themselves, the civil courts or the criminal courts themselves. These are we will be studying about the formal process, how to approach these tribunals, what are the rules that will be applicable in these tribunals, and more importantly, when to approach these tribunals as compared to a civil court. Moving on, chapter number 13, Arbitration and Conciliation Act of 1996. Arbitration is a process which has been introduced under the topic known as alternate dispute resolution, also known as ADR. This concept of alternate dispute resolution arose as a matter of resolving disputes outside of a court structure. Now, once we do civil procedure code, you will understand that the process followed in a civil court is extremely arduous and it is complex, and many people, they are dependent on lawyers to approach the civil courts. And it is for this very reason that it acts as a deterrent. Many people do not wish to approach the civil courts for the same. As a result of which, one of the solutions that came about was something known as alternate dispute resolution, whereby arbitration is one of them. In an arbitration setting, both parties get to choose which court they can approach, in which country they can sit, the language which is applicable, the laws which are applicable to them, the place of arbitration, everything they get to choose, and then they hand over the authority to a certain tribunal, or also known as the arbitral tribunal, to decide the matter for them. So in this particular chapter, we will be studying about two concepts, arbitration and conciliation. We'll be studying about the entire process, how to go about arbitration, how to go about choosing your arbitrators, how will you, when will you know that arbitration is applicable and when arbitration is not applicable. So we will delve into each and every one of these topics in detail regarding arbitration and conciliation. Coming to the next chapter, Indian Stamp Act and Indian Registration Act. Now, Indian Stamp Act was legislated in the year 1899, and the Registration Act was legislated only in the year 1908. Now, in the chapter Indian Stamp Act, it governs that part of, it's a fiscal legislation which governs the applicability of stamp duty to the execution of certain instruments. So you may have noticed a postal stamp, or you may have even noticed an A4 size paper, and at the top of that paper you may have seen a rupee note. Okay, that is known as a stamp paper. And for many of you who have dealt with property registration, or just generally contracts, or even if you've gone as a tenant and executed a rental agreement, you would have noticed that a certain amount of stamp duty is applicable. This chapter, Indian Stamp Act of 1899, governs all the rules, definitions, processes, etc. regarding stamp duty, and when it is applicable, when it is not applicable, how much of the stamp duty is applicable, we will go into a specific detail. Coming to the Registration Act. The Registration Act, I would say, is a kind of continuation of the Indian Stamp Act. While the Indian Stamp Act is considered a general law, the Registration Act is a special law. Now, why would I call it a special law is because there are certain provisions in the Indian Stamp Act which state that in such a scenario, certain documents need not be registered. Now, when I say registered, it means stamp duty need not be payable. Whereas the Registration Act has been introduced so as to make compulsory registration of a few activities, such as registration. Registration is compulsory when you are gifting immovable property, or when you are selling immovable property. Registration is compulsory and necessary. Now, We will go into detail regarding when Indian Stamp Act is applicable, when it is not applicable. Then in the Registration Act, we will be concentrating on sections 17 and 18 regarding when is registration compulsory and when is registration not compulsory. And we will touch on certain other topics such as gift, consequences of registration, not registration, etc. Moving on, chapter number 16, the Right to Information Act of 2005. Now, the right to information came about as a very a new legislation which allowed the public, the citizens of our country, to ask questions regarding to ask questions regarding the administration of our country. Now, you and I know that the government has taken up multiple responsibilities. They have taken up a lot of responsibilities with regards to providing food, shelter, encouraging businesses, expanding the economy, etc. All of these responsibilities fall on the government. As a result of which, there are more and more public offices that have come up in the near past. The Right to Information Act came about as a form of check, and balance on these public authorities. It allows Indian citizens to question how this particular authority is carrying out certain their functions, or whether they are performing their duties, whether they're doing it in a constitutional manner, etc. Now, in this particular chapter, we will study about what the Right to Information Act entails, what amounts to public information, which information is considered secret and cannot be shared, and it will also teach you how to apply to make an online RTI application. RTI is the short form for Right to Information. So we will be delving into these topics, and also we will be studying about all the authorities involved with regards to this law. That is we will be studying about the Central Information Commission, the State Information Commission, the public authorities and their obligations, etc., etc. And lastly, we have chapter number 17 with regards to Information Technology Act 2000. Now, as you all know, we moved into the digital age at a frighteningly fast pace. And 20 years ago, it was very difficult to find mobile phones, or it was very difficult to find a computer, or even a computer with a working internet connection. But in today's world, we see that we see a mobile phone in every person's hand. A mobile phone is necessary for today's living, or a computer is definitely necessary. And now with the advent of the COVID pandemic, everything has moved into work from home. Everything has started going online. Digitalization has become the core requirement of anything that we do today. Now, as a result of which, it was very, very important to regulate how information is stored online, how it is processed, whether information can be sold, when it can't be sold, when does information affect public morality, health, and what information amounts to defamation, when information is correct, when information is not correct. These are the various Information Technology Act touches upon these particular topics. And we will, as usual, just like how we've studied in all the other laws, we will be studying about the authorities. Who are the authorities involved in regulating the movement of information, the storage of information, etc., etc. Now, I would like to move on to the course objective. Now, what will students get out of studying this particular course? The first one is to understand the basic tenets of law, that is the history of law and the sources of law. I discussed in the first chapter, we will be touching upon these points. Then acquire necessary knowledge to interpret and apply all the laws in the present and the future. At the end of the subject, the students will have the ability to read a law and understand as they're reading from section 1 to maybe section 25 to section 30, they will be able to segregate this means this means that, these are the powers, these are the functions, these are the duties, these are the remedies which are available, this law is applicable in this manner, this is how it needs to be interpreted, etc., etc. Then to understand certain principles and theories that form the basis of all laws, civil laws, criminal laws, corporate laws, etc. So like I said, we will be touching upon the core laws such as Constitution of India. We will learn how to interpret these laws using the chapters Interpretation of Statutes and General Clauses Act. We will be studying about the CRPC, the law of torts, with regards to civil laws, the IPC and the CRPC with regards to criminal laws. We will learn how evidence can be accepted, what amounts to proper evidence, what doesn't amount to proper evidence. So these are the core laws which at the end of the subject, the students will have memorized and would be extremely thorough, such that when they read any other law, they will be able to ascertain what is the nature of the law and how it is applicable. And finally, to stay updated with all legislative changes and judicial pronouncements. Now, as you know, we will be studying about the Arbitration Act, the Information Technology Act, the RTI Act. These are all standalone laws with regards to separate areas of that require legislation. Now, you won't just be studying the existing laws. This entire course is designed in such a way that any future amendments, any amendments today or in the future, or any new law itself which is introduced in the future, the students will not be held back because they didn't study about it. In fact, when they look at that law itself, they will be able to understand, okay, this is what the legislature has intended. This is how it's applicable, or this is how it needs to be interpreted, etc., etc. And how will we go about studying this particular subject itself? Is first we will be doing a thorough reading of the institute material, that is the textbook that is provided by ICSI. I'm also teaching you all about the law, I will also be concentrating a lot on the exam point of view. So we will do a thorough, proper reading of the institute material, and I will clear all doubts with regards to, I will clear concepts, I will clear doubts. I will explain with easy and simple examples. Simple examples that may involve person A and person B, and day-to-day examples which everyone will understand. But I will also stick to Supreme Court judgments, High Court judgments, so that you will understand the legal scenario and how it is applicable, how these particular laws are interpreted by the judiciary. Then throughout this entire course, as we're doing chapters, students are open to, you can text me at any point of time, you can even call me and clear doubts. I still have many students who send me text messages, or they even call me asking me, ma'am, what does this mean? What does this section mean? What is the purpose of this law? What is the intent behind this law? And I do my level best to clear as many doubts as possible. And many times I encourage reading, I encourage research by the students themselves. And I can set up certain dates wherein I won't just clear doubts, but we will also touch upon current events, current day-to-day events that touch upon a lot of the subjects that we will be studying about, whether it's arbitration, whether it's Constitution of India, whether it's Evidence Act, whether it's criminal laws, civil laws, or with regards to tribunals, any topic under the sun, we can do a discussion about. And then finally, with regards to the tests. Now, the tests will be conducted in this manner. At the end of each chapter, a test will be conducted. Now, these will be small tests so that the student is we give the chance to the student to go through the entire subject, through the entire chapter and understand and, go through the entire chapter and do a thorough reading of the same. Then after the completion of 4 chapters, we will do quarterly tests. That is, after every 4 chapters, I will be conducting a general test regarding all 4 chapters. Then half portion test is after the completion of 9 chapters. So this would, the half portion test will be conducted by almost the end of October or mid-November. And we will, finally, I will be conducting full-length question papers. That is, we will be doing the past question papers from 2018 December, 2019 June, 2019 December. These 3 papers we will be solving, whereby you will have to sit from 2 p.m. to 5 p.m. and write it in an examination circumstances. So this is how the tests will be conducted. And apart from these tests, we will be having revision sessions. So at the beginning of each class, for the first 5 minutes will be dedicated towards a recap of everything that we studied in the previous class. So this entire course will be taken through revision, tests, and doubt clearing. And since today anyone can ask questions to anybody, whether it is to Google or to me, both of us are open to clearing your doubts at any point in time. Right? Now, the skills that will be acquired through at the end of this entire subject is that you will have an in-depth understanding of laws such as constitution, civil laws, criminal laws, and more importantly, you will be able to apply the principles of interpretation of constitution even to laws such as company law, all the laws that you will be covering under setting up of business entities, and even your income tax laws and your indirect tax laws. And you will have the ability to interpret and apply any laws that are legislated in the future. More importantly, you will also develop good reading habits. That is, I will be encouraging you all to read newspapers. I will be encouraging you all to read additional texts, maybe articles online, such other things, commentaries, which I will be sharing pictures with, etc., etc. I sincerely hope that we have a good learning experience. Thank you and goodbye.